Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios Parts Unknown and FYP Studios West, transmitting across the internet. This is episode 104 of Registry Matters. Happy Saturday, a little bit early, Larry. I'm disoriented because I don't even know where I am. How are you tonight?
Good. I thought it was episode 104, but it's 104, right?
Did I say 103?
No, you said 104, but I'm resurrecting the discussion about 10 versus 104.
Okay. It could be 104, but I just, that's what I was asking you about. Like, for that kind of number, I will say 103 or 104, okay, not 104. And you shouldn't say 104 because that would mean 100.4.
No, it'd be 104. So.
Okay, good. I wasn't sure. I'm reading 104 in the show notes, and I wasn't sure if I said something different.
So you said it correctly. We have been snowed under here in the land of enchantment. We had a blizzard come through on Thanksgiving Day. So depending on your elevation of where you live, you had anywhere from 6 inches in the lower elevations of the city all the way up to a foot or so in the higher elevations of the city. So yes, we've had some nice weather.
Did you have to shovel snow?
I just ignored it and stayed in on Thanksgiving, and usually the moderating temperatures take care of that problem within 24, 36 hours.
Right. And plus, I mean, how much was it? Like inches?
I had about 6 or 8 inches.
Did you really? That's a pretty hefty amount of snow.
So, well, I've had more than a foot here before. This is actually a snow belt where we live.
I had no idea. I don't necessarily. I mean, I've driven through New Mexico before. I can't say I know the geography that well. I've been to Alamogordo a handful of times.
They wouldn't get near as much down in that part of the state as we would here, but yes, remember, we're a mile high.
You are a mile high city like Colorado?
We are a mile. We are absolutely a mile high like Denver. Absolutely.
No kidding. All right. Well, there you go. You ready to go on?
And parts of the city are even higher than a mile, depending on where you are, the elevation of the city.
Certainly. Huh. Hey, if you hear any like chair creaking or anything like that, like, hey, look, you're just going to have to suffer through it. And that's to you podcast listeners, you people.
All right. I haven't heard it yet.
I just heard it as I moved a little bit. All right, Larry, we I guess there's a question that came in. It says, Larry, I understand you people have been sending a plethora of cease and desist letters in New Mexico. Can you tell us about the last policy that forbids cameras on supervised offenders' homes? I don't even understand what this is about.
Well, we've been sending cease and desist letters. Now that we have our staff attorney here, we've been sending cease and desist letters primarily to sheriff's departments because they're the registrars for the state. And we've decided that we're sending the next one to the Department of Corrections because within the umbrella of the Department of Corrections, there's the Probation Parole Division. And they have a number of things that they're doing that we think are unconstitutional, but the one that really triggered it was the one where a person who just got placed on supervision about 2 weeks ago contacted us, and they have this one. Let me just read it, it's not too long. It says, you will not be allowed to have external video cameras or any types of recording devices installed outside your home. If you're unwilling to take them down, you will move.
Yikes. So these are our people putting up cameras to watch those people from messing with them, and they are being told to take them down?
Well, we don't know that that's why cameras are provided for security of the dwelling. I mean, we are in a very high, comparatively crime state, particular property crimes, the home burglaries. I wouldn't say that people put it up to watch them. They may have put it up just so that they could secure their home.
Yeah, I mean, that's why I did it. And not to, quote unquote, secure my home, but to be mindful of vandals or anything of that sort. And the other one, I'm sure I've said this before, is I put one on my front door to prove when I come and go, because I got accused of being out past a certain time one night. So,
well, we have composed a letter, which will go out next week to the Department of Corrections, Probation, Parole. We'll receive a copy, but the Secretary of Corrections will be put on notice that, and I'm going to borrow from George H.W. Bush.
Ooh.
For those who don't remember, when Saddam invaded Kuwait, he said, "This will not stand. I'm making a commitment. This will not stand."
So now are you like Larry H.W. last name?
So, I mean, we are when we evaluate litigation, since we have such limited resources, we look at winnability and we look at preference to be in federal court where we can receive our attorney's fees. But this one doesn't have to be in federal court. If this one is just so obnoxious and so over the top that whether or not we can recover fees or not, if the most prudent place to go is to state court, that's where we're going to go. But I'm sorry, boys and girls, you cannot tell people that they cannot secure their dwellings. You can't have that blanket policy.
That's really bizarre that they would tell them that they can't do that. And obviously that's why you're challenging it. But again, what is their reasoning has to be, but like, we don't want to be recorded by our people, you people, not those people, you people. That has to be the reasoning behind it.
Well, that would be likely what happened. There's probably a recording of them doing things that they shouldn't be doing. Now, of course, when you get caught doing things you shouldn't be doing, you have two choices. You can try to attack whatever caught you and go after the whistleblower, or you can actually try to fix what you shouldn't have been doing. Now, if our speculation is correct, because we haven't heard their reasons, we won't hear their reasons until they respond to our letter, or if they don't respond to our letter, until they respond to our lawsuit, because they will respond to the letter or the lawsuit, whichever one it takes. But we haven't heard their reason. But I can't imagine a reason other than that. I mean, is it possible that someone may have used a security type camera to stare into someone's yard? I don't know the limitations of cameras. Is that possible? I suppose it's possible. But then you apply that sanction to that person. You require them to take their cameras down if you find someone misusing a camera.
Yeah, sure. It just, like, this has been something that's been going on for, I don't know, a decade, where, the citizenry has had cameras on the police to a much greater much greater degree than what has happened in the past. And that's obviously because of smartphones and people just always having a camera on them. Now there's a much higher degree of scrutiny against those people.
And it should be welcomed. If we were operating in a rational world, the people who are providing fine probation supervision and doing nothing wrong, as we've heard so many times, if you ain't got nothing to hide, if you're doing exemplary probation work and you're following sound principles of supervision and you're not being over the top, you wouldn't mind a camera rolling as you come up onto the property. You wouldn't mind being recorded as you interact with the offender or their family.
Hey, Larry, Charles in chat just says, I thought law enforcement always wanted these cameras like the Ring doorbell cameras, as these cameras have helped solve recent crimes. So aren't they almost like splitting the fence there, that they want them in certain circumstances and not in others?
Well, we're talking about the cops versus probation. We're talking about two different things. But like I said, I don't know what their reason is. All I know is I've made it one of our top priorities to find out what their motivation is, and it's way over the top. Along with we're going to be asking them about their prohibition of all romantic relationships without prior approval. We're going to ask them about their overly broad definition of sexually stimulating material. You can't have anything that's sexually stimulating, and they decide what's stimulating. We're going to ask them about their prohibition of possessing a smartphone, which they tell you got to gouge the camera out of it. We're going to find out what their position is on the blanket prohibition on social media access in view of the developing case law. And then we're going to ask them about the prohibition from living within 1,000 feet of whatever happens to annoy the PO, because that seems to be such a subjective 1,000-foot measurement. And based on their answers, we will decide which things, and plus the overly broad use of GPS monitoring, because they have a field day with GPS monitoring. So we're going to probably end up filing lawsuits. I can't imagine that they're going to capitulate to our wishes without lawsuits. So unfortunately, we're going to be in the litigation business in 2020.
And I don't want to drag this on too much longer, but I know that this only applies to New Mexico, but can Paul in North Carolina pick it up and run with it? Can Janice in California pick it up and use these as scaffolding, as frameworks of questions to start digging into these people?
Well, in terms of asking them their rationale behind these policies?
Well, I mean, actually, like filing the lawsuits.
Well, absolutely. The GPS, the case law has already developed quite a bit on GPS after the Supreme Court ruled in Packingham. There's been a number. I mean, we've talked about a number of rulings. So I'm sorry, we have a statute here that says that people will be monitored in real time while they're on parole. But unfortunately, the statute doesn't supersede the Constitution. You just can't arbitrarily do that search and seizure on everybody. So we're gonna ask them if they want to pare it back, and of course they're going to say no on the people on parole, but on the people on probation, they use it too broadly on people on probation as well. So we're going to end up having to sue on the GPS for sure, and we're going to have to sue on some of these, like the social media. They're not going to back off on that. It'd be very surprising, but you always give people a chance to do the right thing before you engage in litigation.
But I mean, like, laws are presumed constitutional when they're made, Larry. Shouldn't you guys back off and let them do their thing?
Well, absolutely. Now, the only thing that's the law is the GPS monitoring for people on parole. None of this other stuff is in statute. All this other stuff is policy. So there's no such presumption there. But in terms of GPS, it's presumed constitutional until it isn't. Now, the Supreme Court of the United States has already said that GPS is a search and seizure, and that the Constitution protects you against an unreasonable search and seizure. That passing a statute doesn't magically make it reasonable. So we no longer presume it's constitutional because the Supreme Court has said it isn't.
Yeah. All right, well, let's move on to a question that we received from last week's episode from Rich. It says the problem, and this is related to, we talked about a case where there was a 15-year limit. Can you give me the brief rundown of what we talked about on that case?
You expect me to be able to remember what I talked about last week?
Let me ask the question and then you can backfill. The problem is, when does the 15-year clock start? To be removed from community supervision for life, the clock starts 15 from the time of your JOC? What is JOC?
I would guess it's your judgment of commitment, but I don't know.
And then removal from the registration is 15 years from your release. I had questions, Larry, about this on a call a few months ago. Every lawyer in New Jersey's interpretation is different. All right, Larry, what do you say? Judgment of conviction is what it is.
What did we talk specifically about? Did we talk about this case last week, or a case on out of New Jersey? Okay, yes. Let's refresh and see what we did. We have a case that we were looking at? Because I've done some research in preparation for this episode, but what did we talk about last week? You remember, I'm old.
I am aware of this. Let's see if I pull up the episode and try and look at it says Registered Forever New Jersey Offenders Fight for Reprieve. That was the title of the article.
Yeah. Did I pull a case with it, or did we just talk about it?
No, you pulled a case, and the title of it is the New Jersey. Well, you pulled the code that talked about when serving 15.
Yes.
Okay.
Yes. Well, then I've done more research after the question came in. So now we have an appellate level decision from New Jersey from December 7th to 2018. So this is, as far as I can tell, still good case law, but they answered those very questions. So I'm surprised that the lawyer, or all the lawyers in New Jersey, can't answer that, because all they have to do is to do a quick, in the matter of Registrant H.D. and in the matter of Registrant J.M., this case was decided by the Superior Court of New Jersey Appellate Division almost 1 year ago, just shy of a year ago. And they answer the question specifically about the statute. Now, the statute, as we talked about last week, is poorly constructed, and there are arguments for exactly either interpretation. But the appellate level court has interpreted it in this particular case, and I've made a plethora of notes here on the case. But the 15 years, you've got two different issues in New Jersey. You have the being removed from registration, and you have being removed from community supervision for life. They have CSL, and then they have PSL, which is parole supervision for life. And so you have two different removal. You have two different potential barriers. You can get off the registration theoretically, or one without the other. But they answered these cases dealt with both, and they answered both in terms of when the 15 years counts. So the 15 years counts for release from community supervision from your last offense.
All right, so 15 years from your last offense. And does that mean conviction, or does that even mean just being charged with something and then dropped?
No, it's within 15 years following conviction or release from a correctional facility for any term of imprisonment imposed, whichever is later. So it's 15 years from your last offense.
Okay.
A judge may grant a petition for release from special sentence of community supervision for life upon proof of clear and convincing evidence that the person has not committed a crime for 15 years since the last conviction or release from incarceration, whichever is later, and that the person is not likely to pose a threat to the safety of others if released from community supervision. So these people, they got convicted in the 90s, but then they got convicted of additional offenses. Each one got convicted of another offense after that. And the state took the position that they weren't eligible to be removed because they had been convicted of, particularly for registration. The state took argued that if you were convicted within 15 years of release from confinement or whichever occurred last, they argued that you would never be eligible. That's what they're arguing. And the Court of Appeals, which is effectively what this is, the Court of Appeals said, no, that's not the case. They said that's absurd because you would have a person who could go 14 years, 364 days, and then commit a minor offense, and then they would be banned for life, and they could go many 15-year periods after that and never be able to be released from the registration. So they said that would yield an absurd result. And so therefore they interpreted it to being 15 years from the last infraction. So if I read this correctly, he's eligible to file his petition for termination from CSL obligations 15 years after his last offense, which he was convicted of. It doesn't have to be the sex offense. It has to be his last offense for which he was released from. He's got to go 15 years free of offending, and then he's got to prove that he by clear and convincing evidence that he does pose a threat to safety of others if released from community supervision. That's what he's got to do. That's
so
what this
for jaywalking,
says.
you get a 25-year sentence, and so it would be 15 years after that offense, after released from that offense.
Well, probably wouldn't get 25 years for jaywalking.
I know, I'm being silly.
So
are you ready to tackle some articles?
So I highlighted some good stuff in here because the court recognizes the danger of legislating from the bench, and they were trying to avoid doing that. So for those who want strict construction as judges, they did do a little bit of legislating from the bench here, and they justified it by saying they were reading the legislative intent for what limited intent they could discern, and they were trying to harmonize the two removal processes from CSL and from registration, but they did do a little bit of legislating from the bench. But it says on page 7, the overriding goal of all statutory interpretation is to determine as best we can the intent of the legislature and give effect to that intent. We do not view statutory words and phrases in isolation, but rather in the proper context in relationship to other parts of the statute, so that meaning can be given to the whole enactment. If the legislature's intent is clear on the face of the statute, then the interpretive process is over. We also consider extrinsic evidence of legislative intent if the literal reading of the statute would yield an absurd result, particularly one at odds with the overall statutory scheme. So that's how they got to where they wanted to go with the registration, because clearly it does say if you're convicted within the 15 years, we went over that last episode, but they decided that would override the purpose of SORNA, which was you could go for the rest of your life and have one minor offense within the first 15 years and you could never get off. And they said that would yield an absurd result.
Okay.
So yeah, but this will be in the show notes for the listener for the to review. But this should answer the question. And I don't know why the lawyers, if I can find this in New Mexico, the lawyers there in New Jersey ought to be able to find this decision.
We certainly realize that you're smarter than they are.
I love it. It says, we presume that the legislature knows how to express its intention, and a court may not rewrite a statute or add language the legislature omitted. And then they cited a case from 2015. So it says here, too, the legislature could have clearly stated that the 15-year period began only after the offender completed the term of imprisonment imposed on the conviction for the underlying sex offense and no other. But again, it chose not to do so. But yeah, this is a good read.
All right, then. So let's move on over to an article out of Reason Magazine, and I'm pretty sure this is gonna be coming down the pike in a bad way. Kavanaugh joins Gorsuch in fight to revive non-delegation doctrine. This is something that we've been covering lately. It's from the Gundy case, and this is about the entity that is in charge of administering, that they would make their own rules. And so then there's a whole faction of people that think that this is a bad idea, that everything like this should be legislated. Did I sort of make a decent synopsis of that?
Yeah, we've discussed this in great detail, and I just encourage people to be very careful what you ask for, because without delegation, government will come to a complete halt. And the sort of the Gundy case was so ridiculous because you had 50 registration schemes operating before the Adam Walsh Act passed, and that did not create the obligation to register. All it did was gave the feds tools to prosecute people who didn't register, and it encouraged the states to bring their registries up in terms of the requirements and coverage of offenders and the duration of the registration, but it didn't create a thing in terms of an obligation to register people that were so anybody who had been convicted prior to that Walsh Act, they already had a registration obligation. But if the government can't delegate, if Congress has to write all the rules for everything government does, just be very happy. You'll never get your veterans disability benefits. You'll never get your Social Security disability benefits, because Congress can never move fast enough with the changing needs of society to define every disabling condition with such specificity and have a listing of what, if you don't allow any subjective judgment for what constitutes a substantial impairment, then, like I say, just be careful what you ask for, because it sounds like that there's a great push to get rid of delegation. And although I recognize that there are some dangers, there's some overreach, it seems like we would try to find out how to deal with the overreach. The big thing is the environmental, the people that are subject to environmental regulations. They do not like that the EPA can say, you can't do this, you can't dump that, they want Congress to spell out everything that the EPA can do, and rather than the rulemaking process.
Yeah, I personally like the CDC example better. I can't imagine the legislative bodies trying to figure out what active viruses and whatnot agents that the CDC should hold on to. I think the CDC would probably be a better agency to handle their specific daily details than our legislature. That is so anti-science as it is.
Well, that would be a good example. OSHA would be another example of what they're trying to rein in, the Occupational Safety and Health Administration. But like I say, we would have a complete grind to a halt of most things that government does. It would be so restricted. But if that's what people want, I can tell people, if you want to live in a country like Somalia, I mean, if you want to live in a primitive country, I mean, that's fine. I don't.
So this article points to that they declined cert to whatever case that they're referencing here, and but it'll come back around again when I guess there's enough meat in there for them to go after it.
Well, cert petitions are filed 8,000 or 9,000 of them a year, so they will keep filing cert petitions, and hopefully they will catch the court's attention, and they're looking for that pivotal fifth vote that they didn't have on Gundy.
And then moving over to an article from The Hill, Pennsylvania enacts law ending time limits for criminal charges in child sex abuse cases. Is this another statute of limitations teardown?
It is. It is, and I'm surprised it took as long as it did with what was his name, the coach there that Sandusky. Yeah, I'm surprised it took this long.
Yeah, because that happened around 13 or so.
Yeah, that was the most bizarre thing in my entire life. To some of the stuff I heard that was going on there. They don't have showers in State College, Pennsylvania. Did you know that coaches 15, 60 years old take showers with 15, 14-year-old boys? I never knew that.
And multiple people knew about it, not just like, I mean, obviously the kids knew that was happening, but apparently other staff members knew about it too.
Well, it would seem like that, okay, assuming they have showers everywhere except in State College, it would seem like if you go to that particular camp and this 55-year-old hairy man gets in the shower with 14 teenage boys, it would seem like that the 14 teenage boys would all tell their parents, that this gross looking guy jumped in the shower with us, and it kind of creeps me out, and it's just that boggles my mind that could go on for so long.
What are they extending the statute of limitations to? Didn't New York make it something to where it was 55 years or until the victim is age 55, I guess? How long did they push this out? I don't see it in here.
Well, on the criminal side, it looks like they just abolished the statute of limitations. There is none.
Good grief. Okay.
So you can have someone come back at any time.
I think in another article that we're going to cover tonight, I think it's about people just being detained for a long, not the one that we dropped, but another one, just people being detained in jail. And, they're saying, memories fade, evidence, becomes less, viable and so forth. And they're talking about that for people just being detained for, days, weeks, months, a reasonably short period of time. And here we're talking about things that are going to go on for, indefinitely, that you would have any way to have evidence and to be able to defend yourself.
Well, we're going to have a lot of people to be convicted. We don't know how it's going to play out in terms of, I'm assuming that if the statute of limitations previously in place had expired, not knowing the specifics, that those people will still be beyond prosecution. That's the way it generally has worked if your previous time has expired. But say you had a 5-year statute of limitations, and this takes effect, and there was 32 days left to run on the previous statute of limitations. Generally, they consider that this new law supersedes the old law. So what you're going to have is people who will be convicted, forced to plead guilty because they will be defenseless on something that happened decades ago. And the pendulum at some point, probably not in my lifetime, hopefully will swing again, and people will realize that we've made it impossible for anybody to defend themselves when you bring in charges decades and decades later.
And
we're going to have to go through that.
Yeah, this all seems to be on the heels of that 1,000-page report, whatever it was, that the diocese put out, or was put out by the diocese, or on the diocese, with all the abuse cases from the Catholic Church.
So yeah, it seems like that. And of course, on the civil side, I feel you're not risking your freedom. I mean, if they take everything you've got away from you, I mean that's damaging. But on the civil side, at least your freedom is spared. But on the criminal side, if you can convict someone and put them in a cage for something that happened 30, 40 years ago, where they are in an impossible position to defend themselves, I find that very problematic. I find the whole thing problematic that we've gone this far, but particularly on the criminal side.
All right, then. So yeah, and it does say in the fourth paragraph, it says the new laws will abolish the state's criminal statute of limitations on childhood sexual abuse and extend the civil statute of limitations. So yeah, for criminal stuff, it's forever.
So yep, and that's the slope we're on across the country, and the people who advocate for survivors, they're not going to give up until they erode the statute of limitations. And do you think that will extend out to just like every crime known to man, including shoplifting, something kind of silly and not, I don't want to say benign, but benign? Well, I think it already has. In Maryland, they don't have a statute of limitations for any felony.
For anything?
Any felony.
Yeah. So jaywalking doesn't count. My often example.
Jaywalking's not a felony, but yes, for any felony offense, there's no statute of limitations.
Okay, but wait a minute. Like, I mean, if you're driving 40 miles an hour over the speed limit, you now have a felony charge, or something like that, right? Don't you push past misdemeanor?
I don't think so. I don't think it's ever a felony to drive 40 miles an hour with the speed limit. Okay,
you could get reckless driving. Is that still a misdemeanor?
But generally all traffic stuff is misdemeanor. So I don't see a felony coming out of anything unless it's vehicular homicide.
I can just see you, you're 70 years old. Like, when you were 20 years old, we have video of you driving like a crazy person, and they go prosecute you.
So, well, like I say, I believe the pendulum will swing, but I don't think it'll happen in my lifetime. I think a lot of people will be convicted. There'll be a lot of suffering, and eventually, when enough people in high places are put into prison for something that has happened decades ago, people like Roy Moore in Alabama. When people like that, enough of those are incarcerated, then I think the pendulum will swing.
And then you put in this article that is about, I don't know, this is probably a 5,000, 8,000 word article from ProPublica. And these judges can have less training than barbers, but still decide thousands of cases each year. I personally find this to be troubling. I don't know that I would necessarily think that they have to be lawyers to be magistrate judges, but I would think that they would have some level of constitutional training besides some sort of correspondence course. The way that the article profiles a particular person that gets dragged into the system is she has a fight with her roommate, and she gets brought in and then sees the magistrate judge, and the judge is interrupting her, and the ACLU says that her constitutional rights were suppressed at least, and she was then she ended up with a criminal conviction and $1,000 fine. When she couldn't pay, she was later thrown in jail, ultimately losing her job and her home. On a magistrate judge that doesn't necessarily know all the policies and procedures that are required? Well, that sounds troubling to me.
Of course, the big thing that came out of this article, this is complete systemic failure in South Carolina. This magistrate judge system, we have a similar system here in my state. The only county that doesn't have that is the largest county that I live in. We don't have magistrate judges, and we have what's called a metropolitan court, which has essentially the same powers as a magistrate court, but the other 32 counties have magistrate courts, and they handle the preliminary first appearances on a felony. They do the probable cause determinations. They handle civil lawsuits less than a certain amount, which that number is not in my grasp at the moment. But they handle landlord-tenant disputes. They handle misdemeanors. They handle all the misdemeanors, traffic violations. So you potentially have the jurisdiction to put someone in jail for up to 364 days on a misdemeanor. Well, if they have multiple misdemeanors, you could potentially put them and stack them for quite some time in jail. Say a person made multiple obscene phone calls. If you stack 12 times 364, that's 12 years in incarceration, less 12 days. So you have what appears to have happened in South Carolina is you have magistrate judges who do not respect that people are entitled to attorneys if they can't afford one. It doesn't seem like that they routinely offer legal services. So the person is standing there in a proceeding that they don't know anything about how the rules work, without representation, facing a criminal conviction up to a year in jail and $1,000 fine, and a blemish on their record. And then the system itself, it looks like it's broken down because the magistrate judges have escaped any scrutiny for their misconduct.
Yes,
and they've escaped any reappointment process. If they're holding over and nobody makes a nomination, it looks like that they've got a little fiefdom going where the Senate
correct.
Puts this is a political payoff for someone who supported a senator. I'll get you a $72,000 a year magistrate judge job, and then if no one else gets appointed, you don't have to go through any process again. You're just a holdover. And I think they said one in the article that had been holding over since 1998.
Yes, and like for a 4-year term or whatever it was.
And so you've got a complete systemic failure in South Carolina. and people's lives
woman,
are being harmed.
when she goes, yeah, and the woman that goes before the court, she doesn't know the rules. I mean, none of us know the rules besides the people like you, Larry. I mean, we don't know these rules, so we need the judge to help us. We need a court-appointed lawyer if we can't afford our own. And in this particular instance, this judge even denied the person to have a court-appointed counsel.
So, well, that's why this is in court litigation, and hopefully that ACLU. God, I hate that group. But hopefully that this lawsuit is successful and they bring some semblance of order. But ours is not that much different here. The 32 counties don't require any legal degree, and they run for office. So they run for the position of a magistrate judge, and they have to go through a certain limited amount of training at magistrate judges school. I forget how many days it is, but they have to go through training. And then they are subject to the to the canons of professional conduct, which means that the state Supreme Court ultimately can discipline them under how they can remove and sanction judges for misconduct. But here we probably have similar problems. If a close enough scrutiny was looked, we probably have very similar problems to what's going on in South Carolina.
There's a funny picture, maybe a third of the way down in the article, and it says that this particular magistrate judge is being sworn in as magistrate. While seeking reappointment, the individual didn't disclose her suspension from the bench from handling cases involving the sheriff's office run by her husband. That sounds like straight up corruption there.
I don't see a problem with that.
No, of course not.
And then you see the one from Dorchester County. The former magistrate Arthur, I can't pronounce that.
That would be Brungleson.
Brungleson.
Yes. Sorry. Oh. Shouldn't laugh at people's names. It's not their fault.
So, but he didn't.
What did you want to say about Brungleson?
Well, he didn't know he was committing anything wrong either when he was with no legal experience. Brungleson handled an estimated 3,000 civil and criminal cases for almost 3 years. Then he learned he wasn't cut out for the job while attending a class on judicial ethics laws. Brungleson realized he had already violated these canons of the previous cases. He hadn't known it was wrong to lower defendants' bail to $10 and then pay it himself.
Hey, well, he was doing good things there.
So then he discovered he had mishandled basic elements of several other trials. He rejected a request for a restraining order against a police officer, saying it would have serious effect on the officer's career. So,
all right. Well, then let's move over to this is Bloomberg Law. I didn't realize that Bloomberg is this the same outfit that does like the Bloomberg News stuff? I didn't realize they had a law channel.
I don't know.
Anywho, whoever Bloomberg Law is, California cops can't search vehicles for ID without a warrant. It's a pretty quick, short read, but it looks like a person gets pulled over and the driver refused to produce a license and registration on demand. And the officer then started searching her purse on the driver's side. And I don't think you're allowed to do that, are you?
It was a 64-page decision, so I decided not to read it.
How dare you?
But what I think is great about it is that the incident to a lawful arrest, they can search your vehicle. They have to do that because if your vehicle is going to be impounded if you're arrested, we have to make sure that we know what's in the vehicle. But see, that didn't work out for him in this case because there was apparently no basis for arresting the person. So therefore, all they were trying to find out was who the person was. And I don't have any ID. Well, that does not create a scenario where the Constitution evaporates. The fact they don't have any ID, then the question is, well, is that a citation offense to drive without a license in California? Probably is. It's probably not an arrestable offense. So there was nothing to arrest a person for. So the California Supreme Court reversed themselves and said that we had previously granted this as an exception, but we've changed our mind.
So you're saying that the Constitution doesn't evaporate just because you can't produce ID? I'm appalled by this thought.
Well, that's it's an amazing thing, but I think that if you can't produce ID, that doesn't mean that the Constitution no longer applies to you.
So you basically just have to be a human to have the Constitution applied?
That's my thinking. Is I think you just have to be inside the country. I think once you're in our country, even if you're here illegally, I think that the rule of law applies to you. I think you're entitled to due process. I just have this strange notion that the founders believed that if you're in our country, however you got here, we have to treat you with certain fundamental rights. Now, that may include a process that deports you, but we still have to go through due process.
That sounds like a liberal do-gooder position you have there, Larry.
It's kind of sick, isn't it?
All right, then let's move over to the appeal. Not nearly as long as the ProPublica article, but still long. And this is in Missouri, public defenders push to put poor defendants on waitlist in an attempt to improve their legal representation. That title even doesn't quite describe it terribly well to me, but it seems to me that if you have money, then they want to push your case through so they have a better caseload average instead of having just the stuff stacked up 4,000 people deep that it says that they do in St. Louis County, and there are only 21 public defenders to have 4,000 people applying for the public defender service. Did I capture that right?
I don't understand the part about if they have money. If they have money, they wouldn't be using the public defender. So
well, that's true. Well, yeah, I guess. But I was just looking at it from the point of view of just being able to push cases through. But yeah, you're right about that. Then what would be the point of building a wait list? Wouldn't they have, wouldn't it be sort of first come, first serve, or at least as far as being able to develop the case to bring it forward?
Well, as I've said many times, we don't get to decide on the defense side when cases come. They come. That's decided by the law enforcement and the prosecution side. So what you're fighting against when you have crushing caseloads as a public defender, what you're trying to figure out how to do is try not to find to provide constitutionally deficient representation, because in a modern society where things are as complicated as they are, if you're going to defend a person with all the forensics and all the experts we have to fight against now, there's an expert for everything. For sound recordings, for DNA identification, for alcohol, for relate it back to how many hours since you drank. There's experts for everything.
Of course.
So what they're fighting against is a crushing caseload and trying to figure out how not to dip below. So if you're representing and you can only handle 50 and you've got 125 on your caseload, what they're trying to say is we're gonna have you waitlisted until we can get to you, which sounds really good, except for if you're sitting in jail while you're waitlisted. Yeah, and therein lies the problem.
Yeah. It says that they have the majority of the attorneys have approximately 1.7 to 2.5 the number of cases that they should have under the recommended caseload standards. Is that like a national standard of how many cases an attorney should have?
Yeah, for there's these recommended, and it's all about the complexity of the type of cases you're defending. But in felony cases, you can't do justice. We've gone through the numbers about how many working days are in a year, and what do we come up with?
Well, there's 2,000 working hours, give or take.
So let's get it down to working days. If you have 5 times 50 weeks, assume a person gets 2 weeks vacation, you got 250 working days, and you got vacation and sick and stuff. So let's say that the average person has 225 working days. If you have a caseload of 125 felony cases, you'd have to plead out one every other day.
Yeah, and I'm sure that some cases take longer than that.
Well, I tell people it's just the basics. Okay, in order to represent a person that's facing the possibility of a felony conviction and a period of incarceration, which most felonies have carry a maximum of substantial amount of incarceration, there's a lot of work to do to figure out before you can even recommend a plea. So you can't handle these crushing caseloads. And the reason why we keep bringing this up, we bring it up state after state about deficient public defense. We've harped on Montana, we've harped on Louisiana. I think we've harped on. You name it. We've harped about this because it's a fundamental flaw I mean, the Supreme Court has said you have the right to representation, and Gideon versus Wainwright some 50 plus years ago, and we have not fully funded the apparatuses to take care and to fully implement Gideon versus Wainwright. We still don't want to defend people, and this is people who are in the trenches trying to figure out a way to not do a sloppy job, and one way is to put people on a wait list. If you're on that wait list, you're not going to like it very much.
Yeah, I wouldn't think so. Mike in chat says, stop plea bargains and grind the system to a halt. I think we've covered that idea before.
Well, that's never going to happen. And everybody says that, but you would have to assume that if you could get every single attorney to go disregard what's in the interest of their clients, which is your job as an attorney, is defense. You're looking for an outcome that's in the best interest of your client. So you'd have to assume that everybody charged with a crime is completely innocent, and that nobody would want to plead to anything. And it's in your interest to plead clients to stuff when they've got overwhelming evidence and they've charged them correctly, or they're willing to reduce the charges to the correct charges where they've overcharged them. It's in your interest to plead your client. That would be totally unethical to go out and say, despite my ethical obligation to get the best outcome for my client, I'm going to go on this wild goose thing to try to bring down the system. That would not be an unethical course of action, and it's not going to ever happen.
Yeah.
So,
but then another article that you provided from the appeal is there's a pattern of police unions attacking people who call for criminal justice reform, especially when they are black. This is, I don't know who these people are. I don't know football players, but this is a Philadelphia Eagles safety. Malcolm Jenkins wrote an opinion piece urging the city's recent re-elected mayor to pick a new police commissioner. And then the police union goes on the attack against this individual, saying how, like, stick to playing football. You don't know what you're talking about. And it feels to me like, not reading the opinion piece and reading the reply, that I mean, like, you're allowed to have an opinion, and of course they're allowed to respond, but they are just defending so that they can do their status quo, like the clip that we'll have up later, like, I'm a police officer, I can do what I want.
Well, I put this in here because those of us who are trying to effectuate reform, we are scaring people because the status quo is what people want to maintain. And whether you build cars on the assembly line at Ford Motor Company, or whether you work for the police, or whether you work for the probation system, or whether you work in the prison system, or wherever you work, you may work at Kroger, you do not want your job eliminated. I mean, can you think of, in your decades on Earth, can you think of someone who was really striving hard to see their job go away?
I mean, that's technically what my job is, but hopefully it never happens.
So you're trying your best to make your job go away.
I mean, if I could code everybody's job away, then I wouldn't have any more code to write.
Right, but is that your goal, to eliminate the need for what you do?
No, absolutely not.
Well, I don't think anybody. So the police tend to feel threatened by these reforms because you're looking at upsetting the status quo, and they do all that they know how to do, which is to attack and attack and attack. And this is what they're doing here in my city. They're doing the same thing here. They're constantly saying untrue things about those who are leading reform efforts. And for what little reach we have, I just want people to be aware. Just because the police say it doesn't make it so. When the police try to scare you to death about Armageddon coming, about how if these things, if the reformists get their way, all these bad things, you don't need to believe everything the police tell you, because Armageddon is not coming if we make some changes.
Of course. There's in one of the paragraphs it says, in 2016, the National Fraternal Order of the Police endorsed the current administration, who has championed federal prison and sentencing reform, but has also advocated for nationwide expansion of stop and frisk policing. The tactic led to disproportionate stops and arrests of Black and Latinx. That's a whole conversation on its own, that Latinx word, people in Trump's hometown in New York City.
Well, and former Mayor Bloomberg has apologized for stop and frisk and said he was wrong. You've heard that, haven't you?
I did. I heard that he backtracked and said, he didn't realize that it was doing to the black and brown communities.
So, yes, he has said that he was wrong.
Then over in the New York Daily News, exclusive, New York prisoner in solitary for nearly 200 days over false positive on drug test lawsuit. Oh my God. This guy, he was in a drug rehab class and program, and he was within weeks of being released. And we covered it maybe 2 months ago where they have these like $5 drug tests, and it sounds like it was one of those. And it comes up that he's positive. So he gets booted and goes off to like a higher security detention facility. And he's there for several weeks, and then they drug test him again, and he comes up positive again. So then they move him off to like the real prison where he's in solitary confinement. And then they're like, oh, these drug tests are all bad. So, hey, they let him go immediately. But it's like the guy spent, 9 months in prison basically for your bunk drug test. That's really terrible.
I put this in here because I know how much you love junk science. So
this is terrible.
I thought you'd love to talk about, and of course, I have a recommendation for anybody to do their own drug testing if you can possibly afford it. Some can't afford it. Some don't have the. If you're in prison, I doubt you could probably you wouldn't be able to make that option have that option available, but. This is the reason why people under supervision here, I tell them, if your number comes up on the hotline, if they've got you calling the hotline, you make sure you stop by the independent dope house and get your drug test before you go to their drug test.
Yeah. Can you talk about the story of the individual that that you recommended or was doing that? Is that okay to talk about?
Sure. We had more than one person, but one particular person it really paid off for because he was on out-of-state supervision here from Texas, and he would have been in a never land of problems if he had been arrested for anything because of the interstate compact. You don't have a right to be released, pending all the steps that go back and forth between the sending and receiving state. And so we told this person, being that we know that you have had drug issues in your past, you need to be tested by a reputable lab every time they test you. And so he says, well, what's that going to cost? And at the time, I think it was like $35 a test or whatever we paid. So we had him set up through our account. So every time his hotline came up, he had the drug test. He stopped by the independent lab and did his drug test. And sure enough, he failed one of these quick tests, and they either had to handcuff him or about to handcuff him, so we're going to put you in jail. And he said, you got to think real carefully about that. And they said, why so? And he said, because I just took a drug test before I got here today. and he said, so you're going to have to put forth the theory that I used drugs after I left that drug test on my way here.
Right. Yeah, the 5 minutes that it took me to drive across town, I decided to smoke some dope or whatever. So they said, well, why are you doing that? And he said, because my attorney. And they said, well, why did your attorney tell you to do that? He said, for situations just like this, in case this arose. And he said, so I think you want to think very carefully about arresting me. And they decided not to arrest him. How funny is that?
Well,
did they change their policy any after that, or did they keep running status quo, just not messing with that dude?
They just didn't mess with him anymore. But no, they didn't change any of their policies. They're still locking people up on these dipsticks and on these quick tests. They're still doing it.
So in the end of this article, it says, yet by mid-September, following nearly 200 days in solitary and 4.5 months after his scheduled release, officials realized they'd made a grave error. Come on, man. It's not that, I don't think it's that hard, but to have some level of integrity in this, unless they're, I'd like to think that people are generally good people and they're trying to do the best job. But this doesn't feel anything like that they're just almost going through the motions and this came up positive. Maybe run another test. Maybe it's a bad batch. Maybe get a different one. Like, you're about to take away this guy's freedom for some length of time. That there should be a much higher degree of resistance to do that.
You would think so. Just your own moral compass would say, look, we want to make sure we have this right. And he may be, now, contrary to what I told Charles earlier, he may actually have damages because in a lawsuit it may come to light that they knew that these tests were not reliable. And if that were to be able to be brought out in the discovery process, then the fact that they continue to use an unreliable mechanism to deprive a person not only of their freedom, but hundreds of days in solitary confinement, he might actually have damages that he can quantify, because solitary confinement is tough. And I think you would be hard pressed not to be able to show that some damage was suffered for extended period in solitary.
I do think that, so it says in that same paragraph, it says the drug tests have been false positives. The drug tests had been false positives according to a new $5 million lawsuit expected to be filed Tuesday. I also believe that later in the article, they said something to the effect of like, hey, everyone that had been locked up for these reasons, let them go. Something like that. I recall reading towards the end of the article.
So, yeah, but do they get damages? I'm hoping they do.
I hope so too.
Because, again, the only thing that changes behavior is in a capitalist system is expenditure of money. And if the system has to pay out a bunch of money, perhaps maybe someone up the food chain next time will say, well, we can't do that. We've got to make sure that we don't find ourselves in it. And it's just like this thing on the security cameras. In my letter, it says you're setting the state up for liability, because if someone's house is ransacked and you wouldn't allow them to have at least a lead on who did it, or maybe a notification while they're at work, because that's kind of what these cameras do, is you can get alerts when somebody's ringing your bell and when somebody's prowling around your yard. So I'm hoping the state is ready for the liability that may befall them.
Do you think that goes into any of their calculations of doing things like, hey, we could do this, but wait a minute, there could be some multi-million-dollar lawsuit that comes and hits us in the ass later?
I don't think so. Not very often, not nearly often enough. I don't think so. I think what goes through their calculation is we can do it because we're the police, and we're going to do it until we're told not to. And we may still keep doing it after we're told not to.
Can I play a clip for you real quick?
Sure.
I can't resist doing this one. So this is what I think about when you say that.
I got my rights to do anything I want to do. I'm a police officer.
That's a teaser for what's coming last. Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/Registry Matters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible. All right, let's move over to the Hill. Kentucky governor pardons a man serving life sentence for sexually abusing 6-year-old. Apparently, this guy got convicted in 2001 for abusing a 6-year-old stepdaughter, but then saying the man was wrongly convicted and commuting his life sentence. It's not a really long article and not a lot of details, but it just, so apparently they got it wrong, and I assume this guy went to trial over the whole thing. And here he is. They said, oops, and they let him go. Doesn't look like there's any sort of settlement coming out of it either. At least it's not stated.
Well, what looks like happens is the child has recanted. And Governor Bevin, who's on his way out, he lost the election just a few weeks ago. Governor Matt Bevin of Kentucky lost to Steve Beshear by just a very small margin. But Bevin is on his way out. And maybe his conscience is leading him to do what very rarely happens, which is a pardon for anyone with a sexual conviction. But this would potentially be used against him if he were to run for a future office, that he let a child molester go. That's the way it would be framed in a political arena. But it may be that his political career, he's decided there is nothing else for him in the world of politics and he doesn't care. But the girl apparently recanted.
That's it. But then, you've said when someone recants their testimony, just like Michael Cohen, like now you know that they've lied about something. You're not necessarily sure which side of the story they lied about, but you know that they've lied. So how do you trust either side of the story?
Well, that's why you generally you get nowhere with recanted testimony unless there's corroborating evidence, which this article doesn't give anything in terms of the other corroborating evidence. But apparently the governor felt it was enough, whatever that corroborating evidence was, to go along with the recantation. But no, a recantation in and of itself doesn't do much, because at that point the person is a liar. Now we've got a child here. Child witnesses do not appreciate the gravity of lying. Now, adult witnesses do it anyway, understanding that they are doing something wrong. But it's hard for a child to fully appreciate the gravity of a 6-year-old, to expect that 6-year-old to understand telling a falsehood, the lifetime ramifications of someone being away, never to return, and what they'd be treated like. And so a 6-year-old, when they get older, they could rationalize and say, well, Mommy told me to do it, or whoever told me to do it, and I was afraid, and now I realize what I've done. But there had to likely have been some additional evidence other than just the recantation that would point towards his innocence, because the governor's office apparently proclaimed him innocent.
Yeah. All right. Hey, Larry, is it expensive to hold old people in prison?
Yeah, I think we talked about that last episode.
So here's an article from the Appeal, the cost of not releasing people from prison. Yeah, I do believe that we had like 2 or 3 articles on the subject. And so here's another follow-up one that talks about the aging population of people in Texas prisons, that it's an exorbitant amount of money. And we certainly know that people age out of criminality, especially if they committed something of a violent crime as a youngster, and then now they're 50 or 60 years old. The likelihood that they're going to go run and be gangbangers is probably pretty low. Anyway, so what else did you want to talk about here, since we covered it so recently?
Well, it's just piling on to what I was doing when I threw this in here, because I'm a firm believer that life, that 3 strikes, you're in for life, or just a life sentence, even if it's not for 3 strikes, a life sentence that doesn't afford anybody an opportunity to be released is a very, very serious undertaking, and this helps illustrate that. Now, this is a conservative state where they pride themselves on being so much smarter. This is out of Texas, and we know how to evaluate prudent use of public resources down here in Texas, and we don't throw money away needlessly here, because we appreciate the people out working, paying these taxes, by golly. Well, here's an example of just show us how much you appreciate these people, because even as the total number in prison has fallen this decade, although by only 3%, the number of people in prison in Texas 55 or older has gone up by 65%. State costs for health care for incarcerated people have gone up by more than 50% in the past 7 years. The main reasons for the ballooning health care cost of an older, sicker prison population. So if you are as conservative as you say you are, and if you believe in prudent use of the public's resources as you say you do, then practice that conservatism and go look at what you're doing in Texas and show us how smart you really are in terms of getting these people out of prison, so you don't have to spend all this money on health care, and you could use that money for other things, including maybe some reentry programs, maybe some rehabilitation programs. Get these old people out of prison.
Rehabilitation and reentry programs, Larry, that's like heresy for you to say those things.
Well, but even if you don't want to do that, just save the money and don't spend it on anything else. But like I say, this is me pointing out that the conservative crowd that says that they're such guardians of the purse, here's an opportunity for you to guard the purse and stop spending all this money on these old people that pose very little threat to the public if they were to be released on some form of community supervision. Get them out of your prisons.
But these people committed a crime, Larry. They should be willing to accept their time for the crime that they committed.
Well, and they have accepted. They've been in for decades. But if you get them out and get them on community supervision, you can put them on Obamacare. You can put them on the federal dole, and you can get your state tax resources diverted to something else. So put them on that federal dole. But you can't do that in the prison. They're not entitled to those benefits.
And I'm thinking that the alternative that you just described would be cheaper than prison, and also better.
Well, I would hope that community supervision is less expensive than all of what they're spending on keeping a person incarcerated. If it's not, then we're doing community supervision all wrong.
Right. All right, let's move over to a Washington Post article that is titled, ICE Set Up a Fake University, Then Arrested 250 People, Granted Student Visas. This one seems to be a little confusing about who did what, where, when, and how, and why. But it does sound like when we've talked about, maybe it was a year ago that we talked about that the government was running half of the child porn sites. That's what this sounds very much like, that the government set up a bogus college to entice foreigners to apply to enroll in STEM kinds of classes, and it was a complete bogus university. And then they're using that to ferret out people that are in the country past their visa dates, and then using that to identify them so they can kick them out.
That's what it sounded like to me. That's
funny.
Well, you have a strange idea of what constitutes funny.
Yes.
Usually you chide me for thinking things are funny, but the reason what I thought was intriguing about it was I constantly harp about giving resources, and when we created this Department of Homeland Security under the conservative administration of George W. Bush back about 2003, whatever it was, early 2000s, in the first Bush term, or the first George W. Bush term. We've got an agency that's ballooned, and then I think ICE is under the Homeland Security. I may be wrong, but I believe that we've got an example of too many resources allocated, and they're looking for something creative to do.
But it does seem to be confusing in the article because there were recruiters, and did the recruiters not know that they were working for a bogus organization? And can you then describe entrapment, that there's an element there that is often hard to overcome? Like, speeding isn't entrapment because the police are just there waiting for you to do it. They didn't encourage you to go do it.
That is correct. The mere fact that a person happens to be a law enforcement officer, and they happen to, if you go out all day long and you're asking somebody, will you help me do XYZ, and you happen to ask a cop, the cop doesn't have to tell you, well, I'm a police officer and you probably shouldn't talk to me like that. The cop can say, now tell me more. Now you want to do and you want to do this, and then the cop can lock you up because the cop did not encourage you, provide you the incentive to do that crime. You already had predisposition. So that's why in the prostitution stings, the defense of entrapment falls apart, because the person shows up wanting to have sex. They show up with condoms, and they show up with whatever types of tools that they bring along, but they show up with alcohol, and they show up intending to have sex. The fact that the officer happened to be law, and you thought that was a hot girl on Craigslist, it doesn't save you. Well, here this is the same thing. These recruiters that were working for the university, on what little information we have in this article, I'm not sure they would have known that they were doing anything wrong. I mean, we'd have to read their criminal complaints. We'd have to dig a lot deeper. But if you get a job with a university, I doubt a university is going to say, and by the way, we're running a sting operation here, and this is all bogus. They probably were told to recruit kids, students, and get them enrolled. And let me
play out a scenario for you that I was just thinking about just now. Call it 2005. I had subscribed to a military email newsletter, and there was a blinky, 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 as we used to see back in those days of the internet. And it said, you only have 10 years from the time of leaving service to use your GI Bill. And I was like, 1, 2, 3, 4. Oh crap. I only have like a couple years left. So I called around. I found a couple of like the online universities, and one of them, it was called, American Intercontinental University. And I talked to a recruiter, and now that I think about it, I'm pretty sure she worked at home. So these recruiters could have just been hired by the feds to do the work of filtering out and trying to find the people working from home, whether that be Starbucks or actually out of their apartment or whatever, and not being any the wiser. They didn't have to go to like the campus, and I'm saying air quotes as if everyone can see me. They would never have known that they were working for a bunk organization.
That's what I'm saying. But it looks like that many of them have already entered pleas to the charges. 7 of the 8 recruiters, all in their 20s, have pleaded guilty and have been sentenced to prison time, according to Ike's spokesman, Khalid Walls.
Interesting.
So,
Larry, we are going to move over to my super fun article. Actually, you shared this with me, but I think this is absolutely amazing. So I want you to stop me as we go through this, through this clip, if you feel the need. I already teased it a minute ago. But here's the short synopsis is apparently these 2 guys had gone shopping at a kind of a hoity-toity shopping center, and they get not quite pulled over, but an off-duty cop tells them that they need to stop and show some ID. And I will play it, and let me know if you want me to stop so we can talk about particular segments of the interaction. You ready?
Yep.
For what?
Because I told you to.
Because I told you to. Are we off to a bad start?
Oh, this is sounding good. Let's keep going.
You haven't have a reason, sir. You didn't pull me over. But you didn't pull me over.
Get the license out, or I'll hit for a backup, and I'll take you out of the car.
Hey, does the cop sound at all like intoxicated to you?
He sounds like he's really got an anger management problem. Seriously.
Call your driver's license.
Call your supervisor, sir.
Get your driver's license out right now.
Call your supervisor.
Please call your supervisor, because you're not pulling me over neither.
You get your driver's license out right now. Show me ID.
Call your supervisor.
What do you need my ID for, sir?
Well, because you want to run your mouth to me.
No, because you was looking at my license plate. For what?
Exactly.
For what?
You don't have the right to run this.
I got my rights to do anything I want to do. I'm a police officer.
Do police officers have the right to do anything that they want?
I think that they do. It's called a contempt of cop. And I don't understand, Andy, the problem with you liberal pointy heads is you're always trying to obstruct the good guys. They're out there just trying to protect the public, and you guys are finding fault and trying to micromanage them. And this is just over the top on your part.
So what you're saying is that these 2 individuals should have just complied.
Absolutely. I mean, if you're shopping at Nordstrom and you're walking out and the off-duty cop comes up to you and said, I want an accounting of what you've been doing and see your license and run you, why would you mind a person interrupting your day to run your driver's license and see if there's any warrants for you and ask you about what you've been doing? And what's the problem? What's the harm in that, Andy?
I think they should have just said FYP.
You can't that doesn't mean anything.
That doesn't mean anything. I'll pull you over and I'll tow your car.
You see, he said.
Driver's license out.
So he's not getting a supervisor. We requested a supervisor.
I don't mind showing you my driver's license, but what is your reason that you're asking?
Because.
Why?
Is because an actual a police term, like a technical term?
I think it is. It's whatever the police says do. You just do what you're told.
Because you're acting suspicious.
About what?
Tell me why he can stop them for being suspicious.
I wish I could explain that. I guess you would have to ask the officer what was, and that's what the gentlemen were doing. They were trying to find out what they had done that was suspicious, and he wouldn't tell them.
We was in there shopping.
I said, show me your driver's license.
What is the suspicion, sir?
Get your driver's license out.
You can't
Just
state
show
the
me your
suspicion.
driver's license. That's all I want to see.
You're not explaining to me. You didn't pull me
I'm
over.
explaining to
You jumped out your car and asked me, did I want to?
Investigation.
What are you investigating?
Look,
You
get
just
your
see me in there
driver's
shopping.
license
I paid. I paid for everything that I bought.
Get your driver's license out.
Sir,
Show me your driver's license. If you don't got no warrants or nothing, you're gone. I don't have no problem.
What is the reason that you're stopping me?
I'm not going to argue with you no more.
I'm not arguing. I'm trying to understand
Show me your
something.
license. What's your name, officer? That's all I want. Because we're following.
Show me your driver's license and you can go.
We asked for a supervisor. You denied us that.
I'm not going to get a supervisor.
I'm asking for your name.
I'm off-duty employment.
You're off duty?
Exactly. Off-duty employment.
If you're off duty, then why are you stopping people?
I'm stopping you because you're suspicious.
You know what appears to be the case?
I know what appears to be the case, but I'm not ready to jump to that conclusion without a little bit more evidence, but it certainly appears that way.
It appears as though that these are 2 black guys who went shopping at a sort of hoity-toity store, walk out with a bunch of bags. They must have stolen it.
Yeah, that's the appearance. So But I'm one
I'll
of
keep
those.
running.
I'm one of those guys that believes in evidence. So I like to not jump to conclusions just on appearances alone.
Why are
About
we
what?
suspicious?
So what'd you come back around for?
Because I want to know
No, you jumped out of the car on us because we
Exactly.
looked at you.
Because I don't know what you guys are doing. Now show me your
You don't know
driver's
what we're
license.
doing? You just seen
Show
us
me
shopping.
your driver's license.
You don't look. You see all these bags in the back of the car? We just came out of the store seeing you, so you
Show
know
me
what
your
we're doing.
driver's license.
You know what was going on because I know he couldn't really articulate what he was trying to say.
Yeah, as far as I know, based upon what happened, I don't think either of us have any reasonable suspicion to believe
Right.
that there's a crime taking place.
Right.
It says there's no reason for a traffic stop at this point.
Right.
So there's no legal requirement for you to identify yourself to an officer at that
Right,
point. So
right.
if you don't want to give him ID, then you don't have to give him ID at that point.
And we tried to be calm and talk to him like that, and he just, I don't have to tell you, he's leaning in the car, spitting all in the car. He's just, I don't know if he's having a bad day. His wife left him. I don't know.
Could be.
I don't know,
Your
man.
guess is as good as mine.
But hey, man, I appreciate
as far
you,
as I'm
boss.
concerned, you guys are good to go. All
Yes,
right,
sir.
take care, all right?
Appreciate it.
Tell me about that. There's no legal requirement to identify yourself to an officer? I thought you did.
Well, I guess it varies from jurisdiction to jurisdiction, but he was not on the road. He was in the parking lot of the store, it looked like.
Yes, that is. I would agree with you there. So they had just left the place, and here's an off-duty cop protecting the mall, which I understand is a pretty common thing. And he doesn't like the way that they look, so he was trying to run a background check on them to see if there were any warrants. But like, that's a Fourth Amendment violation. Yes or no?
Well, I'm going to dig myself in too deep here, but he was certainly in dangerous territory. That's why the on-duty officer, I don't know if that was a supervisor, but that's why they de-escalated the situation. But you can't just stop people and demand a CID without anything. And he didn't have anything. He could not articulate anything. Now, the standards vary from jurisdiction to jurisdiction about what you can stop a person for. Clearly, if they're out on the roadways operating a vehicle, you can stop anybody. And if you got some reasonable suspicion that a crime's been committed, and they are a suspect in that crime, you can ask for identification. But how far you can go when you've got nothing? He had nothing. He just felt like he wanted to run somebody's ID.
Right. Yeah. So when do you cross the line of identifying yourself? Could you say my name is John Smith and your name is not John Smith?
I really don't want to give that.
Then, do you?
I don't want to give that advice. I don't want to give that advice about when you, because it varies so much from jurisdiction. If you're driving, you need to be prepared to identify yourself. If you're operating a vehicle on the public highways, if you're driving, but again, they should have some reason, some articulable reason for pulling you over, even if they have to make it up. You drifted over the center line. Your tail light was out. You didn't signal. Right. They need to come up with something. He couldn't come up with anything. No, he was given several minutes to come up with something, and just because I'm a police, just because I told you to, I'm not going to argue with you. Do what I tell you. Now, what I don't understand, I think I heard that he was fired, but what I don't understand is all the police that are doing good work out there, why you would tolerate this man amongst you, because you would want this not to represent you. You would say, I respect the rule of law. I follow the Constitution. I do my best to provide good service, and I do my best to follow what the guidelines are. And I don't want a person wearing the uniform of my police department interacting with citizens this way. That's what I would be saying. Now, probably I'd have my tires jacked up and knifed, and I'd probably get some blowback. But it would seem like to me you wouldn't want that type of officer working for you. Am I missing something here?
No, I'm with you on that one for sure. You would think that you would want to have the best that you can get in your ranks to represent you as much as you possibly can.
Well, that's my thinking. And you would want, if you're proud of the work you do and your honor and integrity, you wouldn't want a person who lacks that. To me, that'd be like if I was working at the grocery store, I knew that a particular employee was stealing the place blind every day. I already know that the company spends more energy trying to track employee theft than they do outside theft. I wouldn't want to be associating with someone who's stealing the place blind every day, would you?
No, because then that might fall back on you as being someone that's complicit.
Right. So I'd say, look, don't come around me. I don't want anything to do with you. Your morality doesn't reflect mine. I don't share your views that you can do this. And his fellow workers ought to be telling him, no, you can't do this. This is not what a good police officer does. Now, he could have been having a bad day. Maybe this is not what he does, but apparently he got fired.
That's what the title of the article says, or the YouTube clip. Anyway, you can find all of that and everything else in the show notes. And before we close out the show, I do want to say happy Thanksgiving for everybody. And thank you to the half dozen people that joined us in chat. I think that was amazing for you guys to hang out. And Larry, we got 2 new patrons this week, and I'm really excited about that.
I'm very excited, and that's one of the things that we can give thanks for, in addition to the fact that we're in a country that, despite its problems, it's one of the better places to be born. You won a lottery by being born in the United States of America. And it's not perfect, but it's damn good. And
you call that the what lottery?
Well, you won the ovarian lottery.
I love that term. So if you don't know, so we've had Josh Ho on a number of times, and his podcast became a patron of the show this week, and I think that was really awesome. And thank you them for that. And we also got a new subscription from a person named Roddy. And I can't thank both of you enough. I really appreciate all of that.
Well, and I even say to everyone who's not a patron, hope you become someday if you can. But we appreciate that you share your time with us and listen. And I'm hoping that with all what we do and all the fun that we have, that each time you tune in one of these and conclude it, you've learned something about some aspect of how the system works and how we can make it better, because that's what we're trying to do. We're trying
to make definitely the objective.
We're trying to make people's lives better. We're trying to educate one at a time, if that's what it takes, so that person can be empowered and they can go out and make a difference. And these lawsuits we just talked about, for example, I'm hoping that someone heard that discussion and says, gee, I think I'm going to talk to some attorneys here in my state and see if we can do the same thing here that those people are doing in New Mexico.
Absolutely. So Larry, where can people find the website? How do they go find the website to get the show notes, to listen to the podcast, to find out places to subscribe? Where can they do that?
Oh, that would be registrymatters.co.
And not that anybody uses the phone. It's getting all dusty over there in the corner. But how do they leave voicemail messages?
Yeah, we're going to disconnect that phone. 747-227-4477.
How can they email me, not you, because you don't check it, but how can they email me for the podcast?
Registry Matters Cast. That's registrymatterscast@gmail.com.
And how about supporting the podcast? What would be the absolute bestest way that they could support the podcast?
Go to patreon.com/Registry Matters and sign up for as little as $1 a month. It comes out the first of the month, as little as $1.
Seems like everybody could do it.
So as little as $1 and as much as as your heart leads you, which we've got some people whose heart has led them very generously, and thank you.
Mike in chat has said just a few more donors and they can afford the M at the end of the website. For now, we can only afford the CO, not the COM.
Oh.
I'm going to have to think really hard about how I ended up doing a CO and not a COM. I have no idea how I did that. I have no idea. Anyway, Larry, thank you. I hope you had a great Thanksgiving in spite of all the snow. And I will be returning home on Tuesday. And with that, I will talk to you soon.
Okay. Thanks, Andy. And have a good remainder of your trip.
All right. Take care. Bye.